like you both.
Thank you.
That's all set. Got a very soft pen. Very easy.
It's more fun.
Good morning. Good morning, everyone, and welcome to the final round of the first year Moot Court Competition. This year we had a record of 85 students registered to compete. And of those 85, 52 were eligible for oral argument after submitting a brief. And then from there, the top 10 advocates advanced to the semifinal round. So the competitors you'll hear from today are the final 4 advocates standing. Each of them has written an appellate brief and has argued 2 times before today. And that's all on top of their first year law school coursework. So it's easy to say that this truly has not been an easy feat. Today, they will argue in front of an esteemed panel of local judges. The panel includes Justice Ronald Roby from the 3rd District Court of Appeals, Federal Magistrate Judge Chi-Soo Kim from the Eastern District of California, and Judge Kenneth Menemeyer from Sacramento Superior Court. So the case before them today is Nat Cole v. City of Blue Note, and the question before the court is whether a police canine dog sniff of a middle school student constitutes a search under the 4th Amendment. In the City of Blue Note, the police became aware of a drug ring that was organized by high school and middle school students. The officer suspected Nat Cole, a 13-year-old middle school student, of being the leader of this drug ring. And so Officer Davis developed a plan to use his dog to sniff out, hopefully, drugs in Nat Cole's backpack while he's on the school bus. So Officer Davis lawfully stopped the school bus, and Max, the canine, sniffed Cole and alerted the presence of drugs. However, when Officer Davis searched his backpack, he didn't find any drugs. So Max likely alerted the false positive because Cole's mother lawfully takes prescribed marijuana to offset chemotherapy. So Nat Cole sued the City of Blue Note for a violation of his 4th Amendment rights, and the Supreme Court has explained that when police use technology that heighten their senses, a search has occurred. But it has also said that a police dog sniff of a car is not a search. So petitioners for Nat Cole will argue that the dog sniff constitutes an instrument that heightens an officer's senses, and a person's body should be afforded more protection than a car. Thus, the dog sniff constituted a search. Meanwhile, the City of Blue Note will argue that Max, an animal domesticated for over 1,000 years, is not new technology, And second, a dog sniff of a person is no more invasive than that of a car. So if that's true, the dog sniff would not be a search. Today, there will be 2 rounds, and the second round advocates will be ushered into a separate room as the first round advocates argue in front of the panel of our judges. But before I usher the second round advocates out, could you join me in applause as a wish of good luck to all of our advocates?
Wait. All rise. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. The Honorable Chief Justice and Associate Justices presiding. You may now be seated. The case before the court this morning is Nat Cole versus the City of Luna. Is counsel for petitioner ready?
Yes.
Is counsel for respondent ready?
Yes.
Petitioner, you may proceed.
Good morning, Chief Justice, Your Honors, and may it please the court. My name is Carly Haug, and I am counsel for petitioner Nat Cole, and petitioner respectfully requests that this court affirm the lower circuit court's decision and hold that the canine sniff was a search. Before I begin, Chief Justice, may I reserve 2 minutes for rebuttal?
Yes.
Your Honors, this case is about the Fourth Amendment protections provided to a child's body when a search using a sense-enhancing technology is used during police investigation. That principle holds for 2 reasons. First, my client's expectation of privacy was violated. And second, the dog used was a sense-enhancing technology that revealed lawful and private information. Turning to my first point, that my client's expectation of privacy was violated. This court in Katz v. United States held that the use of a microphone on top of a telephone booth constituted a search. Katz provided us a 2-pronged test in order to determine when something is a search. First, the individual's subjective expectation of privacy is
Do
violated.
you think somebody really has an expectation of privacy at a bus?
Yes, Your Honor. The perception of
I mean,
privacy.
there's everybody who's around them.
Yes, Your Honor. Certainly, the perception of privacy is different on a public school bus than in Katz, where a private telephone booth was utilized. However, the expectation of privacy is not diminished of one's body. Your Honors, Katz provides us that Fourth Amendment protects people, and that is what we are here for today. The second prong of the Katz test, that society is prepared to accept.
But a dog sniffing is an odor. So it's an odor of, which is emitted in a bus. It
Correct.
seems to me that everybody in the bus could smell it.
Correct, Your Honor.
So how do you have an expectation of privacy?
Here, nowhere in the record does it indicate that my client was emanating any scent of marijuana aside from the dog's sniff that was
Well, I mean, the
alerted.
dog sniffed an odor of some kind, or else the dog was making it up, and I don't think that's what was going on.
Correct, Your Honor. For this particular case, my client had trace minute residue of medical and lawfully prescribed marijuana that was being used within his home by his mother to treat chemotherapy. Page 4 of the record indicates that my client had no drugs on him at the time of the search. This is further held by this court's decision in Illinois v. Caballos, where it provided that the police sniff of an exterior car did not constitute a search. The key difference here is that in that particular case, the car was pulled over lawfully, there was probable cause via the dog's sniff, and contraband was ultimately located. That brings me to my second point, that this dog was a sense-enhancing technology that revealed lawful and private information.
But doesn't it also reveal not just private information. It actually reveals the odor of contraband. So what you're talking about in terms of the private information, are you talking about what's related to your client's mother?
Yes, I am, Your Honor.
But the odor doesn't actually reveal that, right? So if the canine alerts because there's an odor of marijuana, it doesn't actually reveal the private information. Isn't that correct? It just reveals the odor of marijuana, not any of the background to it.
Correct, Your Honor. This particular dog did not say that his mother was utilizing marijuana to treat her chemotherapy. However, the context of this search lacks probable cause, and that's why the revealing of this information ultimately is problematic. This particular officer got an anonymous tip that named my client. It did not say that he would have drugs on the bus, nor did it say that drugs were in his backpack. The officer was hoping to find my client with drugs, and hope does not provide probable cause for this particular case. This court in Kylo v. United States provided that the use of a thermal imaging gun in order to reveal when the lady of the home was doing her nightly bath or sauna was technology that reveals lawful and private information that's intimate to the home. The Fourth Amendment draws a bright line at the entrance of the home, and that is further affirmed by Kylo. And this case is what we are discussing, or that principle is what we are discussing here. This dog's alerting to the presence of a trace amount of medically prescribed marijuana was a revealing of private information.
How is the odor of marijuana private information?
Your Honor, in Cabalas, it provides that you do not have an expectation of privacy for contraband. However, here it is not contraband. It is medically prescribed, and it is legal to have this marijuana.
I suppose it could be contraband, though, couldn't it? Because with marijuana, you're just talking about the volume or the amount, or whether it's prescribed.
Correct, Your Honor. This particular dog, as noted on page 3 of the record, alerted at both non-legal and legal amounts of narcotics, not necessarily contraband. And here we're differentiating that contraband is not constituted by medically prescribed marijuana.
My struggle with that argument, though, is that for other illegal narcotics, my understanding is that there's not a separation between permissible amount or impermissible amount. My understanding of your argument is that with marijuana, certain de minimis amounts are legal if prescribed medicinally, but other amounts would be illegal. And of course, I don't think it's reasonable to anticipate that a dog could differentiate based amounts. The dog is just detecting the presence. And if there is the presence, wouldn't that be, I think I see it how, I'm wondering why doesn't Cabalas apply here simply because the dog is detecting and alerting for substances that are illegal and potentially of an illegal amount.
Your Honor, I see that I am out of time. May I please briefly respond?
Yes.
Your Honor, in Cabalas, it holds that the use of probable cause is necessary, and here there is that lack of probable cause, and the dog sniff is not enough to constitute that probable cause, such as in Cabalas. Thank you, Your Honors.
Good morning, Chief Justice, Your Honors, and may it please the Court. My name is Kikilani Headland, and I am counsel for the respondent, the City of Blue Note, in this matter. Today, we respectfully ask that this Court reverse the appellate court's decision and find in favor of the City of Blue Note. This case is about upholding the Constitution so that it does not turn every investigation tool or technique into a search simply because it makes an individual feel uncomfortable. We ask this court to reverse for two main reasons. First, a properly conducted dog sniff is not a search that violates the Fourth Amendment.
Does it make any difference where the dog searches, whether it's a car, a bus, or out in the street?
Yes, Your Honor. So the Fourth Amendment is meant to protect people and not places, but places is an important factor in deciding the aspect of reasonable expectation of privacy. In this case, it was in a public place. It was on a public road, on a public bus, going to a public school. There were other numerous students
So
around.
you think a bus is different than a car or a house?
Yes, Your Honor. So a bus is different than a home because the Fourth Amendment gives the strongest expectations of privacy to an individual when they're inside of their home. But those expectations are lowered when an individual steps outside of their home into a public
If you get on a
space.
bus with 10 people or 20 people or however many people are there, it's sort of hard to expect privacy, isn't it? Or is it not?
No, Your Honor. So in this case, there is no reasonable expectation of privacy here. This student, this petitioner, is going onto the school bus knowing that there's other individuals around and other students. So what he brings onto the bus and any sense that may emanate, come off of him are clearly available to the other students to see and to hear and to smell. So there's no reasonable expectation of privacy in that sense.
What about the distance? I'm curious about the distance. The record shows that the sniff was within 6 to 8 inches of the students' bodies. And second, the fact that this individual, Mr. Cole, was a minor, I believe only 13 years old. How does that affect the analysis of expectation of privacy?
Yes, Your Honor. So the officer in this case conducted a lawful traffic stop, and there was no traffic violation that caused this bus to be pulled over. But that's irrelevant because the officer was looking at the totality of the circumstances. On pages 1 and 2 of the record, it indicates that there was an ongoing drug problem amongst the students in this community. The officer also received an anonymous tip that it was this petitioner in particular that was high up in the drug ring, involved in the buying and selling of drugs amongst the students. Furthermore, the students were being taught how to hide the drugs on the insides of their backpack linings. So in order to conduct further reasonable investigation, the dog needed to be taken onto the school bus and walk down the aisles in a close enough proximity to be able to sniff the students and their area. If the dog...
But where were the backpacks located? So if you're saying that they had probable cause to search or sniff the backpacks, where were the backpacks located? And did the sniff occur in that area, or was the sniff of the students?
The sniff, Your Honor, was of the backpacks and which was in the close proximity of the students. It was sniffing around the students' personal space and alerting to the officer if there was the scent of contraband detected. But the Fourth Amendment does not protect personal space. It protects an individual. It's not meant to protect places or any personal space. There's nowhere cited in the authority here.
Well, it does protect spaces in the sense it protects the house. If you're in a home, that's a space, isn't it?
Yes, Your Honor. In that scenario, it would be different since the home is a main protection of the Fourth Amendment due to it being private. When an individual is in their home, they expect the highest amount of privacy from other individuals, from things that can be seen or smelled or heard. But in a public place such as this, on a school bus with other numerous students around, there's less of an expectation of privacy.
So I have this, I guess, analogy I want to ask you about, or hypothetical I want to ask you about. Hypothetically, if let's say they're not on the bus, but it's right outside the bus, everybody's stepping off the bus, and the dog is sniffing the individual students and their backpacks, is there any expectation of privacy in that situation?
No, Your Honor. So the dog in this case was brought onto the bus because if the dog was only to sniff on the outside of the vehicle, like in Cabalas, it wouldn't be able to specifically pinpoint which individual in particular, which student was alerting that dog for the scent of the contraband.
So hypothetically, what if we just slow down the students exiting the bus and just make them kind of walk by deliberately, spaced apart by 5 seconds or so that the dog would have the opportunity to try to detect the smell as it relates to each individual student?
Your Honor, in that alternative, it can pose the risk of the students potentially tossing any drugs if they potentially have it in their backpack. They can switch backpacks. It can give them further time to be able to hide these things and conceal it. And that would create bad public policy because we're not trying to say that a student's feelings and their level of comfortability are more important than the drug problem here amongst the students. Furthermore, it would be bad public policy to put a student's feelings over Fourth Amendment case law. We have a duty to adhere to the Supreme Court precedent, and the controlling case law is clear here. Canine sniffs are sui generis or unique, and these canine sniffs do not constitute searches. There's no legitimate private interest for a minor to be possessing illegal contraband in any sense, and there's nothing in the record that indicates that he has any medical clearance for
Let me
that.
ask you a follow-up analogy. What about just out on a public sidewalk and an adult woman is walking by, adult women walk by carrying purses? Can law enforcement have a dog sniff the woman and sniff the woman's purse? Can an officer ask people to stop so that the dog can sniff the purse and the person individually?
No, Your Honor, that would be different. In this case here, there was totality of the circumstances that gave rise to it. There was specific information that tied this petitioner, in particular on this bus, to the idea that there's a potential drug problem, potential drugs being carried in his backpack. So that would be different if it's just random people walking on the street. Furthermore, petitioner points out that the dog here, Max, is sense-enhancing technology because he heightens the officer's senses. But Max is not a mechanical device. He is a living being using a natural biological sense during the dog sniff. An analogy to this would be that investigation tools used by officers all over the world, like flashlights, binoculars, and prescription eyeglasses. But the Fourth Amendment doesn't automatically turn all of these investigation tools into searches or into sense-enhancing technology, because that would open the floodgates to the courthouse for a bunch of frivolous lawsuits, and it would compromise the officers and their safety and the quality of their investigation. Your Honors, I see that my time is now up. Thank you.
Thank you. Rebuttal?
Just 2 points on rebuttal, Your Honors. My first point is that the Fourth Amendment protects people and that probable cause is required in order for that Fourth Amendment right to be even in discussion. Second, public policy never trumps an individual's right and expectation to privacy. To my first point, that the Fourth Amendment protects people and that probable cause requires specific knowledge, page 1 of the record indicates that a student was arrested off campus. She alleged that students were placing marijuana within the lining of their backpacks. Later, Officer Davis receives an anonymous tip naming my client as possibly someone high up in the ranks of the KOB. It does not specifically state that my client has drugs on him. It does not specifically state that my client is selling drugs. Turning to my second point, that public policy cannot trump an individual's expectation of privacy. Here, the city of Blue Note is extending its ability to protect its citizens. It is trying to protect its citizens by violating their individual rights, and that does not change because my client is a minor. That does not change because my client is on a school bus. Your Honors, this case is about the Fourth Amendment protections.
What if the person here was sniffed walking down the sidewalk?
Your Honor, the Fourth Amendment would still remain, and the individual...
You have a reasonable expectation of privacy when you're out in a public street?
Correct, Your Honor, yes. The Fourth Amendment, as Katz provided as well, it protects people. And here, a dog cannot just randomly sniff you simply because an officer wants it to or hopes that it will discover drugs on you. This case is about the protection of bodily privacy and privacy of the home. And for those reasons, we respectfully request this court to affirm. Thank you, Your Honors.
Good morning, Your Honors, and may it please the Court. My name is Nikki Atkins, counsel for petitioner Nat Cole. Your Honors, before I begin, may I please reserve 2 minutes for rebuttal?
Yes.
Thank you, Your Honors. Your Honors, this case is about protecting the privacy expectations of a 13-year-old on his way to school. Today, we ask this Court to affirm the 14th Circuit's decision for 2 reasons. First, Max is a sense-enhancing dog within the meaning outlined in Kylo v. United States. Second, petitioner maintained a reasonable expectation of privacy in his person, one that society could
Why?
recognize.
He's on a bus with a whole bunch of other people. How do you have a reasonable expectation of privacy when you're in a group?
In Katz v. United States, Your Honor, this Court explained that a person's privacy expectation does not change depending on where they are. Because the Fourth Amendment protects people.
Is that really true? It does make a difference if you're in your home, does it not?
Your Honor, we would argue that the Fourth Amendment, like in Katz, protects people and not places. And the common theme there in Your Honor's question is that a person is in their home, a person is in a school bus. And if a person decides to keep information private within themselves, they have a reasonable expectation of privacy.
Is the expectation of privacy judged by a subjective standard or an objective standard?
Yes, Your Honor. It is judged by a subjective standard as outlined in Katz v. United States. And even if a person is within their home and they decide to make information public knowledge, they don't maintain that reasonable expectation of privacy. Turning back to my first point. In Kylo v. United States, this Court held that a sense-enhancing tool is one not available to the general public. On page 3 of the record, Your Honors will see that Max is a specially trained narcotics dog, one who can pick up on the presence of contraband with a 98% accuracy rate. Although American Shepherds are available to the general public, ones who are specially trained like Max are not.
But in Cabales, the court did not find that the dog sniff there, that was a sense-enhancing technology, right?
Yes, Your Honor. The court in Cabales did determine that the sniff was not a search because of the second prong of the Katz analysis. They found that because the defendants in that case were concealing contraband, they did not have a legitimate interest in privacy. Cabales is distinguishable from our case because petitioner's mother was legally prescribed.
Well, isn't it really distinguishable because it was a car? It was a car, and you don't have a reasonable expectation of privacy in a car. And the court said that, did it not? So we're getting back to this place again. Your expectation of privacy does depend in part on where you are, does it not?
Your Honor, we do recognize that places can change, but the one constant in our reading of Katz is that the consistent part is that there's a person in those places, and the Fourth Amendment specifically recognizes a person as a constitutionally protected area, like a home or papers. And even though there was a person in a car in Cabales, the thing that they were hiding in their car was what they were trying to conceal, which was the contraband. And we read Cabales to go to the second prong of our Katz analysis, which is the legitimate privacy interest in privacy.
I want to ask you about dog sniffing, and is it your position that law enforcement, that every dog sniff is an intrusion of privacy, or are there circumstances where law enforcement could lawfully use a dog to sniff to detect illegal narcotics? What would those examples be where the use would be lawful?
Yes, Your Honor. So one example could be if there's a baseline expectation on the first prong of the Katz analysis where an individual can does not know that they will be subjected to a dog sniff, they have a baseline expectation of privacy. So for example, if petitioner was to walk into school and he knew that drug sniffs were a routine thing that happened at his school, his privacy expectation would change because he can expect that he will be subjected to that sniff and that there's a potential that certain information could become public. But those examples of when a dog sniff would be okay in that situation is different because petitioner was not aware that he was going to be subjected to a sense-enhancing tool, and the residue, the sniff that picked up on the residue directly led to a discovery of private information.
What private information was discovered?
Yes, Your Honor, it was that his mother was legally prescribed medical marijuana to offset the side effects of her chemotherapy.
But that isn't actually what the sniff detected, right? The sniff did not detect that. The sniff detected the odor of marijuana. You're talking about the next step, the use of it, but the sniff doesn't actually detect that, right?
Respectfully, Your Honor, we think that Max picking up on the residue was a but-for cause of, Your Honor, I see that my time is up. May I briefly finish answering your question?
Yes.
We believe that the dog sniff picking up on the residue was a but-for cause of the discovery of the information, and the discovery of the information would not have happened unless Max picked up on the residue. Thank you, Your Honors.
Good morning, Your Honors, and may it please the Court. My name is Ileana Milagros Gutierrez, and I am counsel for the respondent, the City of Blue Note. Your Honors, this case is about a lawful canine sniff that was limited and did not intrude on anyone's protected privacy. Respondent respectfully requests that this Court reverse the Circuit Court's judgment and hold...
Well, why doesn't the respondent have a reasonable, why doesn't the man have a reasonable expectation of privacy in his personal space? Now, that's been used a lot today. Why don't people have personal space?
Your Honor, in 1967, this court in Katz v. United States outlined a twofold requirement that an expectation of privacy must be subjective and that expectation of privacy must be recognized as reasonable by society. In a limited space... He was in a
telephone booth.
Right.
You close the door, you go in there, and you expect that nobody will be overhearing you. But this is a person in a bus with maybe 8 or 10 or who knows how many more people.
Correct, Your Honor. In a limited space, such as a school bus, petitioner is exposing himself in a public space where others can smell him. People are shoulder to shoulder, and the canine was going through the hallways between the seats. So the space that the canine was in was a reasonable space between him and petitioner.
What amount of space would not be reasonable? So you're saying 6 to 8 inches from a student, a 13-year-old, is reasonable. What amount of space would not be reasonable? How about 4 inches?
Well, in this case, Your Honor, the totality of the circumstances must be taken into account because this was a lawful school bus drug sweep, and the canine was there to detect the odor of contraband, as page 4 of the record states. And page 2 of the record even highlights that detectives discovered that students from Blue Note Middle School formed part of the KOB drug ring, and Officer Davis received a tip that petitioner was high in the KOB drug ring. So that is why...
But that's not my question. Mm-hmm. What amount of space, is it the government's position that any amount of distance would be permissible? So I understand that you're saying 6 to 8 inches is permissible. What about 4 inches? What about 2 inches? What about right on the body? Are all of those permissible?
In this case, Your Honor, respondent's position is that the circumstances must be taken on a case-by-case basis, such as in this case, it was on a school bus, and the space was extremely limited. So possibly if they were outside of a school bus in public, it would not be wise for me to speculate what would be a certain circumstance that it would not be reasonable, but in this case, they were limited and confined to only a certain amount of space between the canine and the students, students to students, the officer and the students, and that is why the canine was near petitioner 6 to 8 inches. In Cabayas, in 2005, in Illinois versus Cabayas, this court held that a canine sniff by a well-trained narcotics detection dog was not a search. This court's rationale was that a canine sniff constitutes as sui generis, meaning of its own kind, because a canine sniff is an investigative procedure that is limited to disclosing the presence or absence of contraband, and there is no legitimate privacy interest in contraband.
Let me interrupt you with a hypothetical. Let's say the officer goes into the school and takes the dog to Mr. Cole's locker and sniffs the locker and detects the dog alerts for marijuana. Would that be, is there any expectation of privacy for a student in the student's locker?
Your Honor, that hypothetical is very distinguishable from this situation because in this situation, Officer Davis, as page 2 of the record highlights, all of the information obtained to conduct the school bus drug sweep was lawfully obtained. So in that scenario, it would depend on how the information was obtained. Did the school approve?
Let's hypothesize everything is the same, that the officer has information that Mr. Cole is involved in trafficking marijuana, and that Mr. Cole and that students hide marijuana, in their backpacks, and if Mr. Cole needs a place to stash his backpack during the day, he would put it in his locker. And so can we assume that everything else is the same, but just the sniffing is being done at a locker instead of on a bus?
Yes. Oh, sorry.
Well, so, would your position be that there's no expectation of privacy in your locker? Something with a lock on it?
Your Honor, in that hypothetical, since Your Honor did state that it would be the same circumstances, as page 3 of the record states, the school approved of the school bus drug sweep, and in that scenario, the canine sniffing contraband in the locker room would just be revealing the presence or absence of contraband, no legitimate privacy interest as held in Cabayas. Petitioner relies on Kylo, but that is distinguishable from our case. In Kylo versus United States, it involved thermal imaging that allows officers to see heat emanating from within a home, revealing information such as warmth, light, and other activities within. The court even noted that they could tell if a woman was showering inside. This court in that case was concerned with the intrusion and discovery of intimate details invading a person's reasonable expectation of privacy. But in this case, odor is something that is naturally exposed to the public because odor disperses into the air. Although a canine has enhanced senses compared to that of a human, a canine sniff is different from thermal imaging technology. Thermal imaging can reveal information of what a person is doing within a home through a wall or through the locker. But in our case, Max's alert of contraband on petitioner's shirt did not reveal any information about petitioner's life or his activities. Petitioner contends that the canine sniff revealed intimate details of his life, but the record is silent as to how the information of petitioner's mother's health and her having a legal prescription.
Well, what does petitioner's mother have to do with this whole thing?
Petitioner contends that the canine sniff was a but-for cause of the information revealing her legal prescription and her chemotherapy.
But it's not her expectation of privacy. This is her son, not her. And what if she has medical marijuana? I don't think that has any bearing on anything.
And that is exactly respondent's position, Your Honor. I see my time is up. May I briefly conclude?
Yes.
Your Honors, Like the canine in Cabayas, Max was legally allowed to be on that school bus. He was there to alert to the presence or absence of contraband, and he did his job by revealing the odor of marijuana. That is why respondent respectfully requests that this court should hold the same as it did in Cabayas, that there was no violation of the Fourth Amendment. Thank you.
Rebuttal?
Your Honors, respectfully, I would classify a few points differently than counsel for respondent. First, turning to Your Honors' hypothetical about the locker. In that situation, the locker would not be a constitutionally protected area like petitioner's person, and we want to make that distinguishing point here in this case.
Why? Why isn't it rejected?
Because the Fourth Amendment specifically also protects people, and we believe that this court's holding and Katz controls here that a person's privacy expectation does not change depending on where they are, because the person wants to keep information concealed within themselves.
There is a lock on the locker, and that would provide an element of privacy. So given the fact that nobody else can access your locker, wouldn't the student have an expectation of privacy on the locker?
We read Katz and this case to be the expectation that the individual holds within themselves to conceal certain details. And that turns to Your Honor's point about the types of details that are being concealed. This court and Kylo specifically explained that the level of details and the intimacy of details are not the controlling part of the analysis, because the court would struggle to draw a bright line rule regarding what law enforcement could pick up on. Law enforcement would not know the level of intimate details their sense-enhancing tool would be able to discover. It is simply the fact that any amount of information and details that a person wants to maintain private, as outlined in the first part of the Katz analysis, is that expectation. Your Honors, I see that my time is up. Thank you, Your Honors.
Is it now time for us to provide feedback? Yeah. Okay. So I'm actually going to ask Justice Roby to start.
Pardon? Oh, I thought it's nice to see 4 women here. Far cry from when I was at McGeorge, and very much beneficial. I think you all were great. This is a wonderful constitutional issue, and it's very slippery. And I thought you did very well. And I thought the responses to the questions, and we weren't trying to ask you easy ones. Maybe we did, but we were trying to test you, and I think you came through very well. Very good job. Very well poised, and very articulate.
I agree. Really, really wonderful job to each of you. You were each confident. You also had a good grasp of the record and the law. And you were able to, after each of you answering questions, go back to the points and arguments that you were trying to make without losing that. So I was very impressed. So really, really well done. Thank you as well to your coaches and others, because I'm sure you all really worked very hard on this. And very importantly, a thank you to I think there are a lot of family and friends and parents, so a big thank you to them as well, if we could give them a round of applause. It's it's wonderful to see all of this support here they're here for each of you, which is really remarkable. So really well done. You should be very proud of yourselves. Your coaches should be proud. And I'm a parent as well. All of your parents should be very proud as well.
So I would echo everything. First of all, I did notice that I think all of you made presentations without notes. I will tell you that I appreciate how profoundly difficult that is, and also the amount of courage that it takes to get up there without notes. I guess each of us in our practice careers have different relationships with notes, and we won't go into that now. You can ask us maybe individually about that. Also, what I would tell you, both as a practitioner and from a judicial standpoint, I think arguments are most effective when they become a conversation, and you guys really made, each of you made this a conversation for us. We interrupted you with questions, and you were direct in responding. I will tell you tangentially that and it'd be interesting to hear my colleagues' reactions, but when I ask a question from the bench, if somebody starts to answer a different question, if they don't answer me directly, I pretty much stop listening. And so each of you, I thought, was very good about listening to the question and then addressing the question as directly as you could. The final thing I'll add is that I thought all of you did a great job of anticipating the questions we would be asking, and you were prepared, I think, for our hard questions. And that's one of the hardest but most fun things about preparing for an argument, is preparing to handle problems in your argument or problems in your case. And you guys were all, I think, prepared and poised in how you did that. So kudos to all of you. It was fun to watch you. What's next?
The judges will break for deliberation, and then we'll host the award ceremony soon after. Yeah.
We don't know the names of them.
No, they're calculating it right now.
Hello, everyone. On behalf of the Moot Court Honors Board, we want to say thank you again and good job to all of the advocates who participated in this year's 1L Moot Court competition. Each of these advocates tried their hand at something new this semester and put their best foot forward. With that being said, let's get into our awards. Once we call your name, if you were here, please make your way up here where you will receive your award and take a photo with our esteemed panel.
All right, so this year we're proud to introduce a new tradition in our Moot Court program. For the first time, we are going to be recognizing the top 5 preliminary round advocates as well. The preliminary rounds demand skillful preparation, and these students exemplified just that. So with that, here are our top 5 preliminary round advocates. Roxanne Wright.
Switch it around. Congratulations. Okay.
Maria Lopez. William Ramsey. Tim Morrison. Marco Sumariva.
All 5 of you, huh?
That way? Perfect. Okay. And 1, 2, 3. Perfect. Okay, that's great.
Next, for the first time as well, we will be recognizing our semifinalists. This group of advocates had exceptional preparation, skill, and advocacy, earning them a place in the top 10 of the entire competition. So here are your semifinalists. Sienna Giampioli. Nora Ruvalcaba. Isabella Acosta. Elijah Torres.
Photos, you should bend that back, like behind it.
Congratulations. Sriya Sridhar. And Julian Kranick.
And then I'll have you go a tiny bit that way. Yes, and then, sorry, in the middle that way. Okay, and then just. Okay. All right, 1, 2, 3.
Do you want any of us to move?
Oh no, you guys are good. Okay, perfect. I think we got it. Thank you.
This next group of advocates rose above an already outstanding group to earn their place in the Final Four. Their preparation, composure, and command of the law set them apart at every stage of the competition. With that, we would like to recognize all of our Final Four advocates at this time. Nikki Adkins. Kekulani Headland. Carly Howe. Ileana Gutierrez.
Can you then scooch a little bit that way? Perfect. And then you as well.
Now, our last few awards recognize those who performed at the very top of this year's competition. The Best Brief Awards honored the petitioner and the respondent whose written advocacy demonstrated exceptional legal analysis, clarity, and persuasive reasoning. First, we'll be announcing the brief of the petitioner, which goes to Amelia Peterson. Next, we have the Best Respondents Brief, which goes to Sienna Giampioli and Shreya.
And then smidge that way so we can see the judge in the middle. Perfect. Okay. 1, 2, 3. Couple more. Okay, that looks great. Thank you.
Now we will turn to our esteemed panel to announce the second best oralist, best overalist, and best overall.
Again, we want to share again that we were so impressed with each of the advocates today. So you really did a wonderful job. We want to let you know that it was very close and it was very hard to make these decisions. So you all just did really wonderfully, and you're a credit to yourselves, your families, and then also your coaches and the Moot Court Board who worked very hard in helping you all prepare. So I want to let you know that the scores are based on both brief scores and all oral argument rounds. So let me first start with the second runner-up, and we want to congratulate Carly Huag. And then for the best oralist, that goes to Kaikilani Headland. And the award for best overall goes to Ileana Gutierrez.
Congratulations.
Thank you. All right, 1, 2, 3. Awesome, thank you.
Thank you, everyone. We want to thank all of our competitors for their hard work throughout this competition. Your commitment to excellence reflects the very best of our law school. We would like to extend our sincere gratitude to our judges, coaches, and organizers for their time, guidance, and support. This competition would be nothing really without you. Thank you all to our friends, family, guests for being here today and for supporting our advocates. On behalf of the Moot Court Honors Board, congratulations once again to all of you, and thank you for all joining us today.